All right, well, welcome to AlderTalk, another episode of AlderTalk. And I want to talk about a question that I get very frequently, which is, Mike, what can you tell younger lawyers? And you know what? I'm going to stop using the word younger because younger, older doesn't matter. Newer or less experienced lawyers versus experienced lawyers. What are like the 5 most common mistakes or false impressions that newer lawyers have about depositions? And I want to talk about those. The first is that you can take a deposition within the first month and a half of starting litigation. Remember, within 20 days after service, you can start noticing depositions. And I see a lot of newer lawyers afraid to pull that trigger. And they want to wait until they get X or Y or Z or understand better or whatever, right? And they don't realize that at the same time that they're worried about being ready and waiting, the other side is having time to prepare. And many times the deposition early in the case is the most important thing that the defense needs or the carrier needs to settle the case. And so taking depositions earlier, even if you're not as prepared as, 6 months later, usually settles more cases earlier than not. Second, I see newer lawyers wait to get documents. And in particular, when you have a bus driver, a truck driver, a personnel file that you're waiting for, et cetera. And they wait and there's objections and meets and defers. And so your depo doesn't happen for months later. And they justify it by saying, yeah, but I want to be prepared so I know what's in that file. I have found the most effective depositions where the deponent lies is when you don't have the documents, but they don't have the documents either. If you wait until they send you the personnel file, then the defense lawyer is going over the personnel file with the truck driver. Right? And when you ask them, have you ever been in an accident before, you ever been disciplined, whatever, if they don't know what's in their personnel file, they usually lie about it. No, I've never been in an accident. I've never been disciplined. And then you get the file, and now you've got great impeachment. Conversely, you wait until you get the file, but they now have the file. And they tell you the truth, which you're going to learn anyway. But now you don't have that impeachment. And so I would not wait for documents, go forward. Next, a very common concern that I see newer lawyers have is they lament that they weren't perfect. They lament that they didn't ask all the questions they wanted. They are concerned that they left stuff out. Remember, 99% of the time, that depo will never see the light of day after that depo. The trial is not going to happen. You're going to settle the case. You will never need to use that depo. And so the concern that you have to be perfect, that you have to ask every question, that you have to uncover everything, that you have to do it at every depo, and that you're not going to learn things later, stresses people out. And it takes a depo that could have been an hour and makes it 7 hours. And now when you have a defense lawyer on the other side who knows what they're doing, they're looking at you and going, this guy must be a younger lawyer, less experienced, not sure about his case, not whatever, because he got what he needed, but he went on for another 6 hours. It is okay. If you forgot a question, then ask it at trial. Damn. We're going to cut that out?
Yeah, we'll cut it out.
The last thing that I see a lot of newer lawyers not be comfortable with, that is very effective. And I've seen associates that come in and are newer lawyers that watch me take depos. They'll see me take some depos. I'll ask some questions. You're at fault, and I'll get some answers. And I'll be sometimes 30, 45 minutes, an hour. And then I'm like, okay, thank you. No further questions. And they'll, on the take me aside and go, well, Mike, why didn't you ask them about X, Y, and Z? Why didn't you ask about this, and that? Don't they know about this? I'm like, yes, they do know about that. 1, I'll find out about it. 2, I kind of already know what's there. 3, 99% of the time, it's never going to come up. But when I get what I want, the most important stuff, and then I say, thank you, I got no other questions. The power of that is palpable. The defense lawyer knows that I got what that I think I got what I needed. Right? Many times stopping and not spending another 30, 40 minutes, an hour on trivial type of stuff is very, very powerful. One last thing that I see all lawyers do, certainly newer lawyers, in deposition and trial, is they get an answer, especially a good question and a good answer, that helps them. And then later on, they go back and ask that question again, or I just want to be sure that we're talking about the same thing, or just to be clear, to recap, whatever. And then that witness who gave the answer you wanted, then says, well, now that I think about it, and they change it. Right? It's called gilding the lily. And that phrase is, a lily's a beautiful flower, right? And when you gild something, you cover it with gold. And when you gild a lily, you're trying to make a beautiful thing more beautiful by covering it with gold, and then you kill the flower. That's the same thing. When you get a great answer, move on. Especially in cross-examination, especially in trial. When you get isn't it true? Yes. You're done. You don't then later on go, well, just so we're crystal clear, isn't it? And then they hedge. It is such an important thing to be confident that you get what you want and move on.